Hello everyone, this is Advocate Pawan here. So today we'll be learning about all the important judgments which is required for your exam perspective in a detailed manner, which is very essential for your upcoming exam. Please do focus, please do be attentive, and let's get started. So as said, normal procedure for all the judgments we will be learning by a case scenario, then we'll be linking with our concepts. So it'll very be saved in your memory first. Okay. Pawan files a second appeal. Kamal, the judge, grants an interim stay before framing any questions of law. The Supreme Court says not allowed. The High Court, exceeding its jurisdiction frames the questions first. Very simple. So, if Pavan, I'm filing a second appeal, and the Kamal, the judge, grants an interim stay in that. See, judge is basically giving what an interim stay before giving granting of the questions of law, before framing the questions of law. Is it possible? No, it is not possible. It was decided in which case? U Sudera versus the Yashodhara case. So what happened in this? The Supreme Court held that the second appeal under section 100 of the CPC cannot proceed without framing the substantive question of law. So without framing the question of law, what cannot happen? You cannot grant any particular kind of relief. So let's see in exam what kind of question is asked. The High Court passed an interim order in a second appeal without framing a substantive question of law. According to the High Court, because the interim order was passed at the pre-admission stage by exercising its inherent powers under section 151 of the CPC, thus it was not necessary to frame a substantive question of law. Decide. The answer is C, that is about the High Court erred by passed an interim order without framing substantial question of law, violating section 100. So very simple. Whenever anything is basically been what any relief can be given without framing the questions, cannot proceed further. Okay, second question. Okay, Kamal wins a decree ordering his wife to return the home. She refuses, citing his abusive behavior. Pawan, the judge, says her refusal is valid. Cruelty gives her right for the maintenance. So for example, there's an order which has been asked for the wife to go and stay with the husband. But what happened? The wife is very scared to go and stay. Why? Because of the cruelty of the husband. So as part of it, what do you think? What do you think the decision, is it valid or not? Yes, it is valid because on the grounds of cruelty, the wife need not stay back with the husband. Very simple. A wife refused to comply with a decree of restitution of conjugal rights, directing her to reside with her husband, citing his oppression and cruel behavior as it's a reason for her decision. Determine whether she is entitled to claim maintenance under section 125 of 4 of the CRPC despite the non-compliance with the decree. The answer is what? The answer is option D. Option D says about what? That is about yes, despite the decree directing her to live with her husband, she is entitled to maintenance as she had valid reasons for refusal because of her husband's cruel behavior. So cruel behavior, you are also valid to get the maintenance. Wife's refusal to comply with the decree of the restitution of conjugal rights on sufficient grounds would not absolve the husband of providing the maintenance. That's clear, right? Third question. Okay. Pavan and Kamal attack a man. Pavan stabs, Kamal hits. The Kamal argues for leniency. The court says no. You both shared intent, equal blame and equal punishment. So what happened? Me and Kamal. So I will go kill the person, and the Kamal, what will do? He will attack the man. So what will court say? The court will like Kamal will pray for the court. See, I just hit the person. Well, should I be punishable? Court will be like yes, because both share the intent. So this was a similar kind of case which happened in which one? State of Karnataka versus the Batti Gowda case. So very important. The Supreme Court held that when common intention is established, the degree of injury cannot reduce one's liability. Both participants share equal criminal responsibility. So both of them share the equal responsibility. So let's see the case for it. Let's look at the question. Two accused individuals met at the scene of the incident and inflicted injuries of the victim. One armed with a knife, causing more severe injury than the other, who carried a chopper and inflicted less serious harms. The High Court refused reduce the conviction of the latter from Section 326 IPC to Section 324 of the IPC, citing no prior common intention. So determine the appropriate answer. The answer is very simple. It is option A. The High Court erred the modification, the conviction because the degree of the harm inflicting on the victim cannot be on the basis of reducing the sentence when both accused acted with a common intention. I hope that's very clear. Now, fourth question. Okay. The fourth question says about what? The fourth question is about Mr. X. Let's look at the example. Pawan resigns from the board. Later, the company issues a check. Pawan files a case. Court says He wasn't part of the management then no liability. So if I am resigning and any actions which happen, suppose that I am not responsible. Very simple as that. Mr. X resigned from a directorship of the company before the company issued a check towards a legal enforceable debt that existed during the tenure of a director. Determine Mr. X liability under section 141 of the NI Act of 1882. Very simple. Answer is option B. Since Mr. X resigned before the check was issued, he cannot be held liable. Very simple as that. Fifth question. Okay. Fifth question is what? The Pawan occupies Kamal's land via agreement. So I am Pawan. I'm occupying whose land with by an agreement without no registration. Pawan occupies Kamal's land via agreement without no registration. Later, Kamal's heir sells it. Okay, Pawan occupies Kamal's land via agreement without no registration. Later, Kamal's heir sells it. Court says no deed, no title. Agreement alone gives you no ownership, but you have right to go and argue or file a case. So, for example, I and Kamal, we are both basically signing an agreement where Kamal promises to give me that particular land, but there's no registration done. So, if later, if Kamal's son go and file sells his land to somebody else, will I be held liable? Will can I get the land back? See, court has said that. See, just because of an agreement does not provide you the right, it should also be proving your ownership. So registration is must. Okay. Now, the property owner entered into an agreement to sell with a company, agreeing to transfer the property in exchange for a proportionate share in the company. After the owner's death, his legal heirs executed a sale deed transferring the property to a third party. The company which had possession of the property as a part performance of the contract now claims ownership. Determine the validity of company's claim. Very same example which I gave it to you. They've just put it across over there. The answer is what? All of the above. Why? Because a mere agreement to sell in possession of the property would not transfer ownership of the company. Just because you have an agreement does not mean you have complete ownership. Point number two. Ownership is transferred only upon execution of a sale deed and its registration under the Indian Registration Act of 1908. Okay, third thing is what? Since no sale deed was executed in the company's favor by the owner or his legal heirs, the company cannot claim the ownership of the property. Clear? No? Yes. Sixth question. Pawan's truck is seized with a heroin. Pawan's truck is seized with heroin. Kamal, the judge, releases it for the livelihood, aiding, record everything, photos, videos, no selling it without permission. So Pawan truck is seized with heroin. Okay. The Kamal judge releases it to the livelihood, adding it, record everything, photos, video. So I'll just put it in a very simple way. Mr. Y, the owner of a truck, used as his sole source of livelihood, seeks interim release to the truck under section 451 and 457 of the CRPC. The truck was seized after 24.8 grams of heroin were found concealed during the routine check. The state opposes the plea, citing potential misuse of NDPS Act's objective. Find the most appropriate legal option. So the answer is what? See, the NDPS Act does not bar the interim release of the seized vehicle, and the trial court can release the vehicle under section 451 and 457 of the CRPC, subject to the conditions like videography, inventory, restriction of sale and transfer. So for example, if a person is found, like for example, if I'm driving a vehicle and there is such a certain kind of NDPS products in my vehicle. Now what happens? Can they also seize the entire vehicle? No, they cannot. NDPS Act does not clearly mentions about seizing the entire vehicle. Only the products can be seized, but however, they can record the entire photo, they can record the videos, and we are not supposed to sell it. That is a very important thing which you need to observe. Seventh question. Kamal's use for injunction because the government bans land registration, later ban lifted. Kamal sues for injunction because government bans land registration, later ban lifted. He sues again for the sale deed. Pawan, the judge says fresh cause, new right, the second suit is valid. So very simple, I'll just explain it to you with the help of an illustration first. A plaintiff could seek specific performance of an agreement to sell due to a government ban on the registration of the sale deed on property's location. However, he sought a permanent injunction to prevent the defendant from alienating the property. After the ban was lifted, the plaintiff filed a subsequent suit for specific performance and recovery of the possession. Determine the fate of the subsequent suit under Order 2 and Rule 2 of the CPC. This is an important judgment of the January, which is asked recently. So it's a very important question we're asking is about. The option is D, which is about Order 2, Rule 2 prohibits splitting claims from the same course of action but the plaintiff's subsequent suit was based on the different cause of action due to the government ban on registration. If a plaintiff cannot obtain the relief in the first suit, but it becomes available due to the subsequent event, Order 2, Rule 2 does not bar a subsequent suit as it is an event. Even creates a fresh cause of action. So I hope this is very clear for you, very crisp, very on to the point. They have basically mentioned that in case at any particular stage, for example, what there is a ban, the Supreme Court held that if the plaintiff couldn't claim a relief earlier due to the legal bar. So if I was not able to get a relief before of a legal bar, like a ban, a later event giving rise of a fresh course of action allows a subsequent suit. Order 2, Rule 2, CPC does not apply when the relief is legally impossible at the time of the first suit. So you need to file a fresh suit again and then proceed with the case. Very simple. I hope this is very clearly explained for you. This is a very famous case. Learn it. It's called Kudalur Power Ground Corporation Ltd versus the Chemplast Kudalur and ANR case. Now, eighth question. Okay, let's see. Police drops Kamal from case. So police is basically dropping Kamal from a case. During the trial, a witness names him. Okay, Police drops Kamal from a case. So Police is basically dropping Kamal from a case. During a trial, a witness names him. Pawan, the judge says, closure report can't stop justice. Evidence lets me summon you. Okay. So for example, in a particular case between Pawan and Kamal, just imagine. Now Kamal is the court feel that Kamal is innocent, then they will drop down all the charges against him. But at later stage, when a trial happens, the judge does he have the power to call the Kamal back? In case if they found any kind of new evidences, they can call back, okay, at any particular state. That's very clear for you, right? So a violent alteration resulted in a death. The police filed an FIR charging 5 individuals but dropped 2 with a closure report. During the trial, a witness implicated the dropping individuals, leading the court to summon them as individual accused under section 319 of the CRPC. The individuals argued that they couldn't be summoned due to the closure report. Which of the following is the most accurate statement regarding the trial court's power to summon additional accused under section 319 of the CRPC based on the facts provided? So it's very simple, the same example which I gave it to you. So it is coming under option B, that is about the trial court can summon an individual as an individual additional accused even if they were exonerated by the police, provided that new evidences surfaced during the trial. So they can summon any new person at during the particular stage of the case when new kind of evidences has been found. So this was in which case? Omkar Rathore in ANR versus the state of Madhya Pradesh. Very simple. Okay. Now, ninth question, let's look into it. Kamal's mom, for example, Kamal's mom owns land since 1985 and 1985, adopts Pawan in 1994, sells land in 2007. Pawan claims rights. Court says no. The land was her own before the adoption. Sale stands valid. So, for example, uh, if the entire land was owning by 1985 and if I was adopted in 1994 and sells the land in 2007, I'm basically selling the land in 2007. Pawan claims the rights. So I'm basically claiming the right when the court says no, the land was her own before adoption. So the sale stands valid. Okay. So at later stage, Pawan cannot get the rights because he was adopted the latest. No, certain cases have given different judgments for the same, but you can try to learn the same how the laws has been evolved. The Supreme Court ruled that property owned by a woman before adopting remains her absolute property. Under Section 14, Clause 1 of the Hindu Succession Act, the adopted child cannot divest her of it. Her post-adoption sales remains valid. Okay, the adopted child cannot divorce her of it. The post-adoption sale remains valid. So whatever has been got acquired before, that basically remains valid. So the Supreme Court ruled that the property owned by a woman before adoption remains her absolute property under Section 14 of the Hindu section. The adopted child cannot divorce her of it or post-adoption sale remains valid. So what happens? Even though I'm adopting at the lateral point, he cannot ask the complete rights for it at any particular stage. Now this case differs from vary to vary. Okay, so this was a recent case. Sri Mahesh versus the Sangram. This case was basically decided. So in 1994, Mr. A was adopted by a widow. Miss B, after the death of her husband, Mr. C, prior to her adoption, Mr. B had acquired the property through the sale deed in 1985, which was her absolute property. In 2007, Miss B executed another sale deed for the same property in favor of two parties, Mr. D and Mr. E. Without consulting or obtaining consent from Mr. A, the adopted son, Mr. A claims the right of the property should reiterate the date of the adoptive father of the death in 1982, and therefore the sale deed executed after the adoption should be invalid, as it is not as it was done without his consent. In the light of the facts mentioned and the applicable legal provisions, which of the following is the correct legal outcome? The answer is what? It's actually option B. Very simple. I hope this is very, very, very clear to you. On to point, they have basically covered up everything. So that means if you have been adopted at a later date before the purchase of the property, then you cannot claim the rights over it. But yeah, certain times you can claim if you're the children or not. Now it has differed from case to case. But in this case specifically, remember the case name. It is the Sri Mahesh versus the Sangram case. Now, the last question, let's look at the example. Pawan files for injunction. The Kamal never questions ownership. High Court rejects it. The Supreme Court says no dispute of title, then injunction alone is fine. So very simple. I'm filing a case for the injunction, but Kamal is not responding for it. High Court is basically rejecting it. Then Supreme Court says it. If there is no dispute of the title, then what injunction you have basically bought, that's more than enough. Okay. Let's look at the question now. In a property dispute, the plaintiff filed a suit seeking only an injunction asserting undisputed title over the property. The defendant did not dispute the title and the plaintiff did not seek declaratory relief under section 34 of the Specific Relief Act 1963. The trial court granted the injunction, but the High Court reversed the decision, ruling the suit was not maintained without declaratory relief. Can a suit seeking only an injunction be dismissed solely because it does not seek a declaratory relief under section 34 of the Specific Relief Act 1963 when the defendant does not dispute the plaintiff's title? What is the answer? It's option B. A suit for injunction simply sitter is maintainable and cannot be dismissed solely because it does not seek a declaratory relief under section 34 of the Specific Relief Act when the defendant does not dispute the plaintiff's title to the property. Very same example which I've given to you. In case if you're not disputing at the very first instances, at lateral point you cannot tell that so and so particular thing has happened. So because this case has been gone to the Supreme Court. So I hope maybe a fresh suit can be considered in this particular matter. So guys, this is very clear. These are the 10 important list of questions which I've been learning from the important current affairs judgments. For more details about the classes, about everything, about all the, if you've been interested, if you want to know more about the classes, everything, look at the description box. I would be happy to connect you. Wish you all the best. Good luck. This is me, Advocate Pawan, signing off. Take care. Goodbye. Thank you.